The broadcast is now starting. All attendees are in listen-only mode.
Welcome, everybody. The webinar is about to start in about 30 seconds. So if everybody can settle in, we'll get started promptly at 1 o'clock Eastern Time. Okay, we're going to get started. Good day, everyone. This is Tom Hagee with HB Litigation Conferences. On behalf of HB and 4A Security and Compliance, we're pleased to present this webinar. It's titled HIPAA Compliance for Business Associates, where our speakers are going to answer the question, what to do when your legal client is asked to sign a business associate agreement. We expect to have 80 sites participating on the phone today, so we're very pleased to have all of you on the program. Please note that the call is being recorded. All of your lines are going to be muted during the broadcast. If you're listening to the program over the phone, if you find you need assistance, please call the GoToWebinar support staff at 800-263-6317, and an operator will assist you. Today's presentation is going to be approximately 60 minutes. We'll include questions and answers at the end. You can submit your questions at any time during the presentation by clicking on the question link and then typing the question into the appropriate window. Be sure to hit the send button located next to the box. Make sure we get the question. There are no handouts in the handout section, but the presentation will be distributed to you after the event, so you will have the presentation materials to refer to after the event. This is a CLE eligible webinar. I'm going to break in and announce 2 codes during the course of the webinar. Please make sure you write those down. There are going to be 2 4-digit codes announced at random times. You need to write those down and include them on the form, which we'll send you by email after the event. We want to make sure you get your CLE, so please make sure you get those written down and included on your forms. Also, please take a minute at the end. We started this event and other events based on input from customers and attendees. So please take a minute to let us know what you thought of the event, and let us know if you have other subjects you'd like us to address. We take those very seriously, and we have launched a number of products over the years based on customer input. Please note, too, that these presentations you're about to hear are intended for educational purposes only. They don't replace independent professional judgment or provide complete coverage of all information. Statements of fact and opinions expressed are those of the participants individually. This webinar is a first in the series of the 2016 4A Security and Compliance Healthcare Data Security and Privacy webcasts. These sessions will provide attendees with timely information and insight from excellent industry experts who will discuss various aspects of these important issues facing the healthcare critical infrastructure. Please check the website for a schedule or to register for upcoming webinars. Please let us know if there are any topics you don't see but you'd like us to cover. If we can't cover them in a webcast, we may cover them at the 2-day event that we'll be holding later in the year, October 5th and 6th in Philadelphia. This will be the second annual 4A Healthcare Data Security and Privacy Symposium. We'll have some great keynote speakers and panelists there who will provide more in-depth breakout sessions. So there's a lot of great practical information and good opportunities for networking there. It'll be held at Drexel University LeBeau School of Business in Philadelphia again. So please mark that on your calendars and join us if you can. So for today's program, as I said, we're going to focus on issues for counsel to review with clients before they sign a business associates agreement. We're delighted to have 2 great speakers today. First, we have Ben Goodman, who's an expert on the technical and compliance aspects of cyber risk management. Ben is the CEO of 4A Security and Compliance, which provides information security assurance, risk management, and analysis, guidance on HIPAA, and other federal and state regulatory compliance, incident response planning, training, vendor due diligence, and IT audit and architecture. He is the recipient of ISACA's C-Risk Worldwide Achievement Award. Ben's also the cybersecurity advisor of the Greater Philadelphia Healthcare Innovation Task Force, and he's a faculty member of the Drexel University LeBeau College of Business Executive Education. We're very honored to have with us Barbara Holland. Barbara is the regional manager from the Office for Civil Rights with the U.S. Department of Health and Human Services. Barbara is responsible for management and oversight of OCR's work, enforcing both civil rights and HIPAA compliance in Pennsylvania, as well as in Delaware, Maryland, West Virginia, Virginia, and Washington, D.C. So with that, Ben, I'm going to turn it over to you.
Well, thanks a lot, Tom, and thank you all for joining us today. Hopefully you'll find today's presentation informative and useful. We've got a lot to cover, so we'll just start right up here. Quick overview of what we're going to cover, a little very brief introduction, and also a summary of the references to the parts of the HIPAA rule that we're going to cover for your convenience. Then Barbara is going to give an update on the status of the audit program for 2016, which is exciting news. And then we'll cover our methodology for preparing business associates for life under HIPAA. And then we will leave time for questions and answers at the end. So as I said, a quick introduction, just to backtrack for a second. In 2009, the HITECH Act was passed, which really changed the world for business associates, added new obligations and liabilities, and changed some definitions. Then in 2013, in September, the Omnibus Final Rule became effective, and that enshrined some of those changes and made them clarified some of the aspects of the rule as well. And the upshot of it is that over the past couple of years, more and more business associates, or more and more organizations, have been becoming business associates and recognizing the complex challenges associated with that. And it's really a significant change for an organization, both in terms of time and investment. And it is an interdisciplinary effort requiring legal expertise as well as in-depth privacy and security expertise, and a component of risk management, which we will also talk about. So that's kind of a quick context of what we're doing here. And just again, for your convenience, the HIPAA Omnibus Final Rule is a big rule and covers lots of details that we're not going to be speaking about. We're really focusing in on the security rule, the privacy rule, and the breach notification rules. And we'll touch very briefly on the general administrative requirements with regard to civil money penalties. So without further ado, I'm going to turn this over to Barbara for her update on the audit program.
Thanks, Ben. As Ben said, a lot of the HITECH Act put into effect a lot of the things we're going to be discussing today, including the audit program. The Office of Civil Rights at HHS is now required to audit covered entities and business associates for compliance with the various requirements. The office began a pilot in 2011 through 2012. We completed it in 2013. That pilot audited only covered entities, not business associates, and it was spread. The audits were spread. We had about 150. We conducted about 150 audits, spread across various sizes of entities, large and small, and various types, from hospitals and small group practices up to health insurers and clearinghouses. This current year, calendar 2016, our plan is to move forward with full implementation through samples of covered entities and business associates to audit those entities. What I'd like to just highlight is with respect to the findings out of the pilot program. Over 60% of the problems that we found were related to compliance with the security rule. And I think it's fair to say that given what we're finding through breach reports and also with complaints, those problems continue today. Just briefly with respect to privacy, the privacy rule, the big problems we found were with the notice of privacy practices with respect to access to medical records by individuals and with respect to complying with the minimum necessary disclosure requirements of the rule. On the security side, I can't emphasize enough the fact that the risk analysis piece of that in the pilot program was where we found the biggest problems. And again, that continues through the evidence we find through breach reports and in complaints. So with respect to advising your clients, that's really an area where you really need to emphasize the importance of that. We also found difficulties in meeting the media requirements with respect to mobile devices and disposal of records, and finally with respect to audit controls and monitoring. Going forward this year, we're planning about 200 desk audits. Again, we're going to be targeting certain provisions of the privacy rule, breach notification, and the security rule. And I would suggest that you take to heart some of what I just discussed with respect to what was found in evaluating the pilot program. We're going to be looking at 150 covered entities and 50 business associates. So business associates for the first time will be included in the audit program. We plan to conduct 50 on-site audits, 40 of which will be covered entities and 10 business associates. Again, we're looking in particular on device and media controls with respect to encryption and decryption of information, with respect to safeguards, both physical and electronic and network safeguards, as well as training. That's a big focus. And with respect to risk assessment. Ben, can you move the slide? I don't know.
Yep.
Oh, that's it. At any rate, just let me also note with respect to this that the audit protocol is on the existing audit protocol is on the existing OCR HHS website. But as the initiation of audits gets closer, there will be more information posted on the website, as well as specific notifications to those entities selected for audits. With respect, and finally, with respect to expectations, I think I'd like to emphasize that your entity's responses to the request for data and documents, the more timely it is, the more complete it is, the more responsive it is, the more likelihood the audit will be favorable to your entity. We will, at times when necessary, ask for clarifications or additional information so that it's really important that the documents your clients provide accurately reflect what we're asking for. Failure to submit responses or delay in submitting responses may lead the auditor to refer the entity to a region in OCR for a compliance review, which will be much more extensive than the audit. So that's what I'd like to put out there for your information on audits.
Great. Well, thank you, Barbara. And we'll move ahead here on the next piece here and probably come back to some of those issues that you raised. This is an overview of the methodology that we use for working with business associates and bringing them into compliance and implementing the compliance plan. The first step in the process is probably pretty obvious in terms of determining if your client is a business associate. What we have found is a lot of covered entities have simply papered their vendor lists with these agreements without giving too much thought to whether their vendors are in fact business associates, and we'll talk about the implications there, but we certainly want to make sure that determination is made right up front and nobody signs a business associate agreement that doesn't really have to. Then, assuming that they are a business associate, to try to limit the obligations in that business associate agreement and sync that up with any services contract that is defining the services that are being provided. The third step is to use that input from the contract and the business associate agreement to establish the compliance plan and figure out what aspects of the rules are required, what are the details of the business and the environment that needs to be addressed, and we come up with a plan of action and milestones, a POA&M, for the implementation of the programs. And then the fourth step is actually something that is often overlooked. It's establishing a risk management plan. So no matter how good your implementation is from a compliance and security standpoint, there is always residual risk, and that risk needs to be addressed through, there are a couple of means that we typically look at for doing that, including cyber insurance and contractual risk transfer and so forth. So we'll talk about that as well. So first step we'll look at is the question of determining whether your client is a business associate, and I'm going to let Barbara again talk about what OCR does in terms of determining that question.
Okay. Well, let me say, first of all, signing a business associate agreement doesn't necessarily make you a business associate. I think that reflects what Ben just indicated. Some vendors or some covered entities require vendors to sign BAAs, but don't actually look at whether the BAA falls within the definition of business associate. The statute basically provides that a healthcare provider, a health plan, or a healthcare clearinghouse is a covered entity, and any entity that contracts with any of those covered entities or serves as an agent for any of those covered entities with respect to electronic protected health information is necessarily a business associate. So those are the folks that need to be identified as having business associate agreements. By the same token, if you don't have a BAA, if you represent an entity that doesn't have a BAA, it doesn't necessarily mean you're not a business associate. At the relationship, whether there's an agency relationship, whether the entity is dealing with protected health information. Some vendors, some third-party vendors who believe they just are a pass-through entity, they don't really touch the electronic information in any meaningful way. Some of those vendors have asserted to us that they are not really business associates. That is not the way we look at things. Even if you're just a pass-through entity from a hospital, say, to a medical practice, and you're dealing with passing through lab results, you are a business associate as far as we're concerned. Cloud vendors in particular are among entities, vendors that think that they're not business associates because they just give a key to somebody, some entity that keeps the information in the cloud. We don't buy that argument because the cloud vendor generally also has access to that electronic protected health information, we view them as business associates as well. The definition is contained within the Omnibus Final Rule. It includes any entities that create, receive, maintain, or transmit, emphasis on transmitting with respect to what I just said, protected health information on behalf of a covered entity, or entities that provide services for a covered entity involving the disclosure of protected health information. In particular, I think we're all familiar with some of the portals that our healthcare providers rely on to allow patients to access their medical records or parts of their medical records. The vendors that provide those portals are, in fact, business associates and need business associate agreements with those health systems. All downstream entities also, downstream from the business associate, so subcontractors, subcontractors, if they also create, receive, maintain, or transmit the health information on behalf of a business associate, they are also, in OCR's view, business associates and need a business associate agreement. Who is and is not a business associate? We just can provide some examples. A hosting provider, for example, tech support help desk, patient safety organizations, health information organizations, or these health exchanges that have popped up in most states across the country or many regions across the country, archive and record storage entities, and again, cloud-based services, including cloud-based answering services. Those are generally business associates. Generally not business associates are entities that provide things like janitorial service, laundering services, telephone companies delivering services, and I could add penguins. That's an inside joke, but penguins are not business associates.
Generally speaking, they're not.
Generally speaking. And for all you lawyers out there, just realize that law firms may, in fact, be a business associate. Law firms frequently obtain electronic protected health information on behalf of clients in the case of malpractice services or other types of services for clients. The attorney-client privilege does not exempt you from the requirements of HIPAA, so just keep that in mind for those of you who have that kind of relationship with your clients. Other attorneys may be recipients of impermissible disclosures, so keep that in mind.
And that was something that came up just last week with us, with one of the attorneys we work with, who received an accidental disclosure, and has a policy for handling that, letting them their client know, and it's a bit of an awkward call to make, but you need to kind of have the appropriate procedure for handling that. It happens more often than one would imagine.
Ben, you mind if I butt in, or is that too late? Because I already have.
No, go ahead.
I thought of interrupt. Thanks for the penguin reference. I was afraid that was going to make its way into this. The first CLE code is 8254. Your first CLE code is 8254. And please, I see some questions are starting to come in, so please take advantage of that. You've got two great speakers on the phone, so ping them and they'll give you their insights. We'll get to as many questions as we can at the end. Again, that first CLE code is 8254. Thanks, Ben.
Great. Okay, so we're going to continue on our way. We'll try to get to your questions at the end. And if we don't have time to answer all the questions, then we will certainly try to get to you post event. So sorry, just to go back a quick second here. We're talking now about the business associate agreement, the second step in this process. And just sort of summarizing, many organizations, at least previously, would simply sign the business associate agreement to close a deal. They didn't want any legal paperwork to get in the way of getting their contracts. And it's really not a very good idea, even if OCR doesn't recognize them as business associates. It could cause all sorts of problems for them. And as a contract, and many organizations we've encountered have said, well, we're simply not going to sign the agreements. One actually rather large hosting company had a business associate agreement that basically said, we do all kinds of security and compliance work, and listed all of their bona fides, but then they also said, as far as HIPAA compliance goes, that's all on you. And that, of course, is not a real business associate agreement, so even though it said it was. So refusing to sign, as Barbara noted, is not getting anybody off the hook here. So, making that determination is really important, and reviewing what's in the agreement is key. And we will often review these and work closely with our attorneys, associates who are working with the clients to identify things that may be onerous for the business associate. So there's HIPAA compliance requirements on the privacy rule, facilitating the covered entities compliance. That's something that business associates need to do. Reviewing any delegated responsibilities of the covered entity. So covered entities can delegate certain privacy requirements to a business associate that might not be part of the rule itself for business associates, but would be included in their disagreement. And then the other piece is again, we're just highlighting a few of the elements that we see pretty often, making sure that all of the downstream vendors and subcontractors who are in fact business associates have properly executed business associate agreements, something that business associates would not necessarily be thinking about. As far as the security rule goes, that is something that business associates need to comply with in total. And we'll talk more about that in depth in a couple of minutes. The notification rule checks the definition of a breach. We have seen business associate agreements where they define the breach differently than is defined in the HIPAA omnibus file rule. And sometimes it makes it somewhat onerous because you also have reporting requirements. And so if there might be loads of incidents that don't rise to the level of a breach, but the business associate agreement may put certain obligations on that business associate with regard to those incidents. Also timelines. So as far as the rule goes, business associates are supposed to report breaches without unreasonable delay, upon discovery, and in no case longer than 60 days from the date of discovery, or when it should have been reasonably known. We've seen business associate agreements that have 48-hour notification requirements, which in many cases is impossible to comply with. So again, those are things to watch for, as well as delegated notification requirements. So some of the business associate agreements include things like, okay, you as a business associate will cover the breach notification costs, and as well as, as I said, the deadlines, sometimes liability, insurance requirements, indemnification, use of subcontractors. These are all clauses that are often thrown into these BAAs and can be negotiated. Just to clarify, there are really at least two kinds of business associate agreements. The upstream business associate agreement between the covered entity and the business associate. So, that's one type of agreement that will have certain clauses. We've seen those used inappropriately with downstream business associates. So, and oftentimes these are simply copied and reused where the relationship is different, and so those types of agreements need to be separate and distinct, and then of course the agreements all the way down the chain are also going to have some differences.
And if I could just chime in, Ben, we've seen in some of our breach reporting and investigations that the covered entity may not, in fact, may reside within a parent structure, and the parent does not actually bill directly, but may in fact deal with electronic protected health information on behalf of its, say, hospitals within its system. In that case, the covered entity is the hospital and the business associate may well be the parent. So keep that in mind, again, when you're counseling your client.
Okay. Let's get into the actual compliance activity. So this is the kind of the meat of what we do in terms of building the compliance plan and developing a security program as well as a privacy program. This involves the implementation of information security, development of policies and procedures, making sure the BAAs are in place with those vendors and contractors, conducting an annual risk assessment, and also doing that risk assessment in the event of any major changes in the environment. We work with some startup organizations that are in the process of developing systems, and so as those systems come online, you need to do system definitions and identify the scope of those impacts and do the risk assessment work there as well. And also the annual employee training. This is something that Barbara mentioned, and it's something that comes up in all of the rules that we're going to talk about. Incident response and breach notification plan. This is extremely important. It's kind of like your fire drill. Well, it's your plan for responding to a fire as well as the testing of those plans. Something that is extremely beneficial for these organizations. And doing a cost-benefit analysis. Obviously, right up front, you want to make sure it's worth it to become a business associate, but also as you're going through and evaluating which controls to implement and how to prioritize your programs and so forth, that's an important piece. And when I say benefit, it's in terms of its value as a control, privacy or security control. So how do we do? So we start with the business process. We look at the business and the organization and how it's working with the covered entity or the other business associates, and really kind of getting a handle on what they're doing, looking at the assets that are being used. Both, and assets can include data, they can include people, they can include computer systems, and they will have different categorizations in terms of the sensitivity of those components. So we look at that and we try to identify those things that are the most sensitive and the most in need of protection. And we will look at the system and analyze the system and really look at who's accessing the data, where is it going, what are the processes that are being used, is it being transmitted and stored. Key thing here is the exchange of that data, both internally within an organization as well as externally to third parties. This is an area where you need to make sure that data exchange agreements are in place as appropriate. And also it's a key area where there are vulnerabilities that are often overlooked on the periphery. Systems that are just out there that people drop files or receive files back and forth are often points of vulnerability. And then for organizations that are developing software or products, we look at that development life cycle, and we want to make sure that security and privacy is being considered at those earlier stages of design and development and not something that's slapped on at the very end after the fact. We look at the threat evaluation as well, and different organizations will be facing different threats. If you look at the, I don't know if you folks have seen the announcement today out of OCR of a penalty against Lincare, where they had employees who were taking healthcare records and storing them in their cars and going to various locations. And so an organization that obviously they messed up, but many organizations actually need to do that kind of work out in the field. The threats to that kind of an organization are going to be very different from a cloud-based electronic health records hosting company, so where all of the data is in the cloud, and they may be looking at threats from state actors or hackers or power grids going down, things like that. So each organization has its own threat profile, and we'll look at that, and that's how we do the risk assessment based on all of that information from the assets and their systems and looking at their threats. And just to give a sense of the scope of these different rules that are part of this process, the privacy rule is much longer, more standards and implementation specifications. Fortunately for business associates, much of it does not apply to them. You have to obviously go by what's in the business associate agreement and the contract, but there is quite a bit that does apply, and so you have to identify where their compliance requirements are. The security rule, a little bit smaller, but very complex requirements and implementation specifications. And I'll note here that implementation specifications can be either required or addressable. And addressable does not mean optional. It means that you do an evaluation based on the risk assessment of whether those implementation specifications apply as written, or if you can replace it with an equally restrictive control, equally effective, or if it doesn't apply at all, then you need to document that, and that's part of the risk assessment piece. And finally, the breach notification rule as well has the same standards and implementation specifications that need to be addressed. We've talked a little bit about this, the privacy rule compliance, and the fact that the business associate is not required to comply with the entire rule, but many of those components are required, and these are just a highlight of a few. Training is one. Minimum necessary is another. Barbara, do you want to give a quick summary of how necessary has come up as a problem in these breach reports and things?
Yeah, I'll give you one of the, a very egregious example, and that is actually it may not be the best example because it was a serious error on the part of the covered entity, but this was a situation involving litigation, custody litigation in a divorce case, and the covered entity was served with a subpoena requesting medical records from the year 2000 or 2002, something like that, to date. And instead, the covered entity just copied all of the medical records going back into the late 80s and early 90s, which included mental health and drug rehabilitation records, which had a very profound impact on this custody dispute. That covered entities, neither covered entities nor business associates should be just blithely providing access, even under a subpoena, to all medical records. You have to very carefully look at what is being asked for, and then to the extent there is a requirement to provide a record within that ask, you also have to make sure that what you're providing is the minimum necessary to comply with the request, and redact any other information that is not necessary to comply with the request.
Thanks for that. And we've seen similar kinds of improperly applied or breaches of minimum necessary. It's something that is, training is definitely very important on. Sale of PHI, that's actually something that we've seen in business associate agreements that, when I ask the business associate if they actually do, they say, no, we would never do that. I was like, well, okay, so why is that in there? The facilitation of covered entities compliance obligations, again, for business associates that may cover any number of things. One thing that we've come upon a number of times is business associates having to facilitate a covered entity's request to amend a patient's record. And so sometimes that gets complicated when there's backup files and so forth that need to be accessed, but those are things that business associates need to be prepared to do. And then again, we've talked about the reporting of breaches of unsecured PHI. We'll get to that a little bit more in the breach notification rule. Security rule compliance, as we said, there are 42 standards. Nearly half of them are required and half are addressable, and this is where you rely very heavily on your risk assessment. So as we said, these are going to be different for the different organizations as far as how these things get implemented and what kinds of decisions are made in terms of prioritizing the controls that are implemented. Training, again, is required here. And training is going to be different for organizations that have IT staff as well as everyone from the senior management down through the person who's at the front desk is going to need some training. Breach notification. So the business associate is required to notify the covered entity of impermissible disclosures of unsecured PHI. And as we said, we talked about the definition of a breach. It's been revised in the omnibus rule, and there are 4 factors that are required in terms of the evaluation of this breach. The first is the nature and extent of the PHI involved. So is it 2 records that were accidentally sent to the attorney? Is it 50,000 records that were left at a coffee shop? The unauthorized person who received the PHI, so again, is that you, the attorney, or is that some stranger or someone who stole a laptop, or just some stranger who, or maybe the records are blowing around on the street somewhere. These are things that have actually happened. So then the biggie is whether the PHI was actually acquired or viewed. So if a laptop is stolen and you have a log of encryption of the drive as of the morning that it was stolen, then in all likelihood that data on that drive is not viewable. On the other hand, obviously, if it's again blowing around on the street or something like that, or there is no proof that it's encrypted, then that's a different story. And I think, Barbara, am I correct in assuming that if a laptop goes missing and it's not encrypted, it's assumed to be exposed, right?
That's correct. That's correct.
Yeah. So then the final factor is the extent to which the risk of PHI has been mitigated. And there you're looking at, was it accidentally sent to you and you've notified the business associate and destroyed your copy and documented the destruction, or is it like this example floating around on the street somewhere? So all of those factors go into a PHI breach risk analysis, and so that's something that needs to be done post-incident, and it may turn out that the incident is not a breach based on that those criteria. Okay, so I think we've covered these other issues again with the civil and criminal penalties apply. The audits apply, and investigation. So if there's a complaint or an incident, a breach that's reported, then the OCR will potentially come in and do an investigation. Do you want to speak to that, Barbara?
Right, and frequently, at least in this region, what we will do, if the breach notification itself is complete, thorough with specificity about what the covered entity or business associate has done to mitigate any potential risk. That, for example, it's conducting a forensic analysis to determine what happened, when it happened, how to prevent it from happening again, and steps of that sort. If that kind of specificity is in the breach report, and it seems to us, that the covered entity or business associate is moving forward seriously with what's happened and taking steps to prevent anything happening again. In some of those cases, we will just ask for final investigation reports or final risk assessments, and if those are adequate, we'll just close out the case rather than conducting an in-depth investigation, since it just doesn't seem to be necessary in those kinds of cases in all situations. But in other cases where breach reports have not contained that information, or whether the breach appears to be highly egregious, we will go in and conduct an investigation. In some cases, we may turn it into a full-blown compliance review. We have the authority to do that. So just be aware that our enforcement authority under HIPAA is pretty broad, and we have discretion to move forward. I also want to emphasize two things, because we see these over and over and over again. I've said it before, I'll say it again. We've seen it over again in both breach reports and in complaints, and that is the need for a really active risk assessment analysis program, including a compliance plan, so that these assessments should be done periodically, every year, every couple of years, and whenever some major change happens within the entity that would increase or change the risk of some kind of vulnerability. And the second thing to emphasize is training. You could have the best risk assessment, the best policies and protocols in the world, but if your staff are not trained and trained repeatedly, something is going to happen. And again, this shows up, I would say, almost every breach might have been averted with adequate staff and repeated staff training. So just keep those in mind as you're advising your clients.
Thanks for that, Barbara. We're going to move on to the fourth. We're about to move on to the fourth slide until that happened. Sorry about that. Let's go. Sorry, fourth section. Okay, here we go. Sorry about that. Tom, that would have been a good time for you to jump in and give that code.
The code, as you requested, is 1353. If everybody could write that down, please. The second, this is random, Ben. Whenever Ben screws up, we'll read the code. The code is 1353. I hope that was clear, and we still have a few minutes left, and I see more questions have come in. Please take advantage of that. Back to you, Ben.
Thanks, Tom. Sorry about that. Hopefully everybody can see the screen again. Let's move on with the risk management piece and the four classic risk management options of avoidance of risk, mitigation, acceptance, and transfer. And risk avoidance really comes into a couple of pieces that we've already talked about as far as determining costs and benefits of becoming a business associate. And also, in some cases, does the client really need PHI in order to perform their services? A couple of times we've seen where they can reconfigure things a little bit and cut themselves out of that flow entirely, which is obviously a big savings for them. Eliminating unnecessary contractual obligations, we've talked about that quite a bit, where possible in both the business associate agreement and the services contract, and limiting the scope of exposure. So in some cases, we've seen organizations that are able to outsource, for example, hosting to a HIPAA-compliant cloud provider, and eliminate the onerous task of setting up all that infrastructure themselves. The number of other ways that can be done, and trying to reconfigure their systems, and that's something that we look at and we advise on with our clients. Risk mitigation, this is kind of the meat and potatoes of what we've been talking about. Identifying the threats and vulnerabilities, implementing the controls, meeting the compliance requirements, all of that, including the training and the risk assessment. Those are all mitigation tools. Risk transfer, this is something that really doesn't get enough attention, both through contracts and through insurance. You want to make sure that you're not the recipient of risk transfer wherever possible, and really look at insurance. This is an area that's more and more common. Contracts are requiring it, but a lot of organizations may think they have coverage in their GL. Generally, it's excluded from general liability. Sometimes there are riders. We've seen these riders. Sometimes the riders provide as little as $5,000 worth of coverage, sometimes $50,000, often very inadequate. Unfortunately, there is no standard cyber insurance form in use today, and many brokers still don't understand cyber very well, so it's something that you really have to pay attention to and look at carefully at sublimits and exclusions. In the interest of time, I'm going to not get into the details of the cyber insurance things that you would like to look for. If you have questions about this, we're happy to answer. One thing I will call out: fines and penalties, making sure that the policy covers regulatory fines and penalties. Those are important and not in all cyber policies.
And I would just, maybe you want to, since we're talking to lawyers, add resolution agreement settlement amounts, because a lot of times we settle cases, and we don't call it a fine or a penalty. We call it a
That's a great point. Great point. Thank you. Right. So, making sure that the language in the insuring agreement covers that. So I think we were talking, Barbara, earlier that there's really only been two penalties, HIPAA penalties. The rest have all been resolution agreements.
Correct.
So just to kind of summarize our service offerings, we work with law firms to provide full-service compliant, HIPAA compliance offering, privacy, security breach notification, compliance plans, and implementation. We do offer on-demand e-learning for business associates and covered entities, and that is a little bit unique in that the focus there is really differentiated for the types of HIPAA entities, not something that's always found in the other offerings that you might see. We do the risk assessments. We work closely with our law firm associates to develop policies and procedures, and do the incident response, breach response plans, as well as exercising those plans with tabletop exercises and vendor due diligence. So those are just some of the things that we do.
Thanks, Ben. You ready to jump over to questions?
Sure. We'll just quickly note the series continues with monthly webinars. We'll let you look at that, but more to come. And finally, the second annual Healthcare Data Security and Privacy Symposium is on October 5th and 6th. And with that, we'll take some questions. So let's see if we can.
I think one of the first ones is, are medical marijuana dispensaries considered BAs? And in this region, we don't have any experience with that because we don't have medical marijuana laws yet in the Mid-Atlantic region, but I know other parts of the country do. I think it would depend on the relationship between the dispensary. My understanding, but I could be wrong, is that they're really independent. They don't have any relationship with healthcare providers per se. So, but I think that's something that the dispensary attorney would have to, or the covered entity attorney would have to determine.
Interesting question. We haven't come up on that one either. I think, again, you'd look at the flow of the data and the relationship to kind of dig into that.
Right.
Another question here on a copier repair and maintenance. There's a famous breach which involved data that was left on a copier hard drive. Barbara, do you want to weigh in on that one?
Yeah, I think it would depend on what access the copier vendor or repair people have to the information on the copier. Obviously, copiers they have memories. Fax machines even have some ability to remember things. So, and if the repair people have access to that information, that may be something that the attorney representing the BA or the covered entity may want to look into, or figure out ways to limit that access in the contractual arrangement with the vendor. I wouldn't, just normally assume it has to be a BA. I think it will depend on the nature of the relationship, the amount of access, whether you can limit the access contractually.
So corollary to that would be organizations that may be dialing in remotely to servers and systems, for maintenance purposes, and there we look very closely at what level of access they may have to PHI, and oftentimes there's a pretty clear distinction between what they're accessing and whether they can in fact access the PHI. Certainly for help desk organizations, they have generally been considered business associates if they can access the desktop of a user whose system has access to or may contain PHI. So I would be pretty careful about that one. Barbara, do you want to take the question about the
two BAs? Yeah, the question is, when two business associates of a common covered entity are sharing data at the covered entity's request but not providing services to one another, do they become BAs of one another? Just on the face of that question, I would say no. They each must be BAs of the covered entity, but if they are not having any interaction with one another, there doesn't seem to be any need for a BA one to another. Now, having said that, I think it would be prudent to keep an eye on the relationship, because these relationships can change from day to day, month to month, and if it does change and one BA, is asked to have a relationship with the other BA, then obviously there needs to be some kind of agreement. And then the next one, it seems to be to me, are companies who contract with covered entities to copy and produce medical records business associates? Again, off the top of my head, I would say yes. They have access to EPHI. They're providing EPHI to patients on behalf of the covered entity. That seems to me, on the face of it, a classic business associate function. But if it is just incidental contact, contact from a CP. I don't know what CP is. Perspective, especially
cloud provider perspective. Maybe?
especially a small business. Oh, maybe this is a second.
Yeah, that's a different question.
Okay.
This is about limitation of liability. The incidental contact question is, incidental exposure often within an organization. So if somebody overhears a conversation or happens to walk past a screen that's got PHI, that might be incidental exposure.
Right, of course.
But if an organization's business is to log into servers that contain PHI, again, I think it's going to be, look at the facts on the ground and be as specific as possible. But again, our experience has been that those help desk organizations and maintenance, technical maintenance companies, if they really do have access, and oftentimes they have administrative access. It's privileged access. So that is enabling them to make a complete copy of the PHI that might be residing on the system.
Right.
So those are often business associates. And there's that last question.
I think that's yours.
Yeah, this one is an interesting question about limitation of liability for cloud providers, and if you're working with Amazon or Microsoft, and what they try to do in terms of limiting their liability. Doesn't that put small providers in a very difficult position in choosing business associates? And the answer is yes, no question about it. I'm not sure about. I'm not an attorney, and so the limitation of liability question, whether they can actually get away with that from a regulatory perspective, I don't know.
Yeah, I think. Well, I would just say we've encountered a lot of situations where cloud vendors have these adhesion, what in the insurance trade used to be called adhesion agreements. They sort of dictate the agreement, and they will not negotiate on. In some respects, it's understandable because they're dealing with lots of different contractors. But from a HIPAA perspective, we're not going to look at if. Let me rephrase that. If there is liability, there's liability. We're not looking at indemnification provisions. We don't look at whatever contracts to limit, to see whether there's a limitation within the contract. That's not what we care about at OCR. If there is liability, then we're going to look to the party liable. So the answer is the cloud vendor can't limit its liability if it's going to be a BAA, other than a contract with the covered entity, and the covered entity needs to deal with that directly with the cloud vendor.
Is that it?
All right.
I think that's it.
I think that's all the questions.
That is all the questions. Thank you very much, Barbara and Ben. Thank you very much. It was a good session. I'm glad you both could make it to the call too. So that was a good session today. And as Ben said before, he was rudely interrupted by someone. This is going to be a series, so you could look for more of these webinars. He posted his schedule. I promise you'll get email from HB about them. He's going to be covering HIPAA vendor and management, due diligence, privacy and security, international and domestic health data exchange agreements. None of these titles are short. I'm seeing a theme. Mobile medical device challenges, and then cyber insurance in June. So there's more to come. So look forward to Ben and Barbara. I hope we can have you back on one of these. You all should have your 2 CLE codes that were announced randomly, random times during the presentation. Please use those to complete the CLE form, which you'll receive from HB by email.
Oh, Oh, just to
wait.
interrupt,
Please
I'm
interrupt.
sorry to interrupt you. I just want to catch people before they leave. An OCR person who's been on this call just emailed me to suggest that HB Litigation is having a marijuana insurance webinar tomorrow.
Thank you for that that plug. Yeah, we are having our marijuana insurance tomorrow. It is so far one of our best sellers for some reason, but I'm questioning some of the people who are signing up. But no, it's actually it's really
Well, maybe this marijuana question should be asked at that seminar.
yes. We'd like to invite that person to come back tomorrow for that webinar. It is going to be a good one, so we're looking forward to it. Thank you for that suggestion, by the way, and that plug. Um, So we'll adjourn the meeting now. Please take a second to fill out the survey. Tell us what other things you'd like to see here. Also, if you're interested in working with us on webinars, we'd like to hear that as well. Ben also mentioned, save the date for October 5th and 6th when we'll be working with Ben as well as Drexel University, the LeBeau School of Business, again to do the 4A Security and Compliance Symposium. So again, Barbara, Ben, thank you very much. And I'm going to adjourn the webinar and look forward to working with all of you again. Thank you.
Thanks.
Thanks, Tom. Thanks, Barbara.